Robert Koopman is the Hurst Senior Professorial Lecturer at American University and former Chief Economist at the World Trade Organization. Thanks so much for joining us. On what grounds do you think the Trump administration will most likely use to fight this ruling?
Well, you've already heard that they're going to appeal the ruling, but I suspect what they're going to try to do is use other provisions in U.S. law to try to impose tariffs on our trade partners. So there are already 10 investigations going on. We have 6 Section 332 investigations that are on national security. We have 3 302 investigations, which are about unfair export practices, and 1 Section 201, which is about U.S. sector being injured. So I think they're going to use many of those tools, those 3 in particular. The challenge for the administration is that each of those takes much longer, requires an investigation. It requires engaging with the private sector and the public and hearing from our trade partners about the specific elements that they propose as trade measures in there. That will slow the process down. It will allow those who would be adversely affected by the potential tariffs to actually weigh in publicly. And typically what happens is that the initial proposed policies and those things get changed. So I think those will be the main tools. The difference compared to IEEPA is there's not as much flexibility. There's much more engagement. It takes much longer time.
Time is of the essence, of course. Can the administration proceed with tariff deals pending this appeal, or must all of it be stopped in the meantime?
No, they can continue negotiating, although the president will complain that his leverage has been temporarily removed. But I think all the trading partners realize that regardless of what the outcome is in the appeal process, that this president intends to raise tariffs on imports and encourage reshoring in the United States. There's another provision he can use. It's a temporary provision called Section 122 of the Trade Act of 1974 that would allow him to put for 150 days a 15% tariff or quotas on imports. So that gives him much more unilateral action, but the time frame is limited compared to those other actions. And Congress can extend those.
Yeah.
Go ahead.
Sorry, news just coming in that I want to ask you about. Trump apparently could ask the Supreme Court to halt this block as soon as Friday, with his advisor, Peter Navarro, saying they've got lots of other tariff options available, even if the Court of International Trade ruling stands. What's your sense hearing that information?
So I think that's exactly where I expected them to go. And I just listed these other legislative tools that they can use to raise tariffs, including that last one, Section 122, which the president can do very quickly. But for a time-limited period, 150 days, Congress could then extend that. So that would give him immediate leverage once again. But I suspect they'll wait to see what the Supreme Court says. The Court of International Trade ruling is pretty clear. It's pretty stark. It'd be really surprising to me, but I'm an economist, not a lawyer, if the Supreme Court would actually overturn the CIT ruling.
All right, thank you so much for your insights. Robert Koopman is the Hurst Senior Professorial Lecturer at American University, also a former Chief Economist at the World Trade Organization.
Thank you.